Hello and welcome to my webinar, Protecting and Maximizing Your Estate. I want to thank you for taking the time to join this webinar today. I want this webinar to be educational. I feel the best way to help people understand is to share stories and examples. Because of the amount of information I will be going through, if you have any questions, feel free to schedule a complimentary consultation with me and we can discuss your concerns. You can do so by clicking the Grab Your Spot button on this page. Today, we are going to learn about why you need an estate plan to protect yourself, your family, and your life savings. Many people have an unclear perception of what they think estate planning is and are unaware of some lesser known but greatly beneficial uses for estate planning. You will also learn how to avoid probate court, save money on taxes for your family, and understand how life insurance can play an important role in estate planning. This presentation is purely for informational purposes only. The information pertains to Michigan laws and there is no attorney-client relationship created based on your viewership of this webinar. I am a family man. I have a wife, Dina, and 3 beautiful children, Lexi, Aria, and Jacob. As the oldest sibling in my family, I have had to be responsible and a great role model. This has allowed me to have the mindset of taking care of people around me and looking out for them. I love helping people. If I can help someone with anything, I will try to help them myself, teach them how to do it, or put them in touch with someone who can help them. I have learned a lot during my life, and I have figured out so many different nuances in many fields that deal with our everyday lives. When it comes to planning, I consider myself to be a proactive planner. This is not just in estate planning, but in other ways as well. What does this mean for you? I offer help outside of just creating estate planning documents for you and your family. Anytime you have a question that deals with a major life event, whether it be getting married, having a child, or buying a home, changing jobs, you should contact me first. I go out of my way to help people out. As a fiduciary, I am looking out for your best interest. I am not selling you a product or services. I am making a commitment to do what is in your best interest. This is me with my family. I am carrying Jacob, and Dina is there with Aria in the star shirt, and Lexi is on the far right. My dad had to drop out of school at a young age to provide for his parents. When he got married and had me and my siblings, he was stuck working day and night so that we didn't have to. All he wanted was for us to go to school. Unfortunately, my dad suddenly passed away 1 week before the final exams in my first semester of law school. It was rough on me and my family during that time. But my dad was smart and had an estate plan in place. It allowed for us to grieve his death without being burdened with extra nonsense that no one wants to go through during that time. I want to provide that same help to other families. It is never going to be an easy time. It is not going to replace a loved one. But having an effective estate plan in place provides so many benefits. Estate planning is a tool that everyone should have. Think about how much of a difference it would be in your life that for you and your family if you had fiduciaries taking care of you since birth. If you had a fiduciary financial advisor, CPA, lawyer, etc., then you could have prevented so many problems from occurring in the first place. Estate planning is an essential tool in preserving what you have worked so hard to earn for the people you work so hard for. Many people do not understand what estate planning is. They have not been educated on the importance of estate planning. Most people think that if they aren't rich, they don't need estate planning. They also believe that estate planning is only for when they pass away. This is why most people call me and ask me to prepare a simple will, because they don't own anything. First of all, a will is a backup, last resort document. It may not be the document you need to achieve your goals. Secondly, estate planning covers way more than just passing your assets to your loved ones when you die. Third, if you own a home, have children, or own a life insurance policy, then estate planning is crucial in maintaining your estate should something happen to you. This is true even if you do not die but cannot take care of yourself. For example, if you develop Alzheimer's, become disabled, or are in a coma. A will only covers your assets and guardianship of your minor children when you pass away, and your family still has to go to probate court. Probate court is extremely time-consuming and can be very costly. What happens when you are alive and cannot take care of yourself or your children? Your family has to go to probate court even if you have a will. Here are some misconceptions. Without a will, your spouse doesn't get 100% of your assets. Your spouse gets about $200,000, then your assets are split evenly between your spouse and your kids. If there are no kids, then your assets are divided between your spouse and your siblings or your parents. A will can be thrown out by the surviving spouse, and they can take what's called a spousal election, where the court will throw out the will and it just goes by intestate succession. Power of attorney. If you're married, your spouse cannot automatically do things for you on your behalf. Have you ever tried calling a bank, lender, or any other provider that has your spouse's name on the account but not yours? What happened? Did they talk to you? Probably not. This is why you need a power of attorney. What happens if you're alive but cannot make decisions for yourself? A will does not fix this issue. Once you pass away, these power of attorney documents no longer work. We see this all the time. This is where you need more documentation to carry out your wishes. I had a client call me and tell me that she was on a property as an owner along with her grandmother. Her grandmother passed away before her, but the way the deed was written, the granddaughter didn't automatically get 100% of the property. Each of them only owned 50% of the property. I told her that we would need to go to probate court to fix this issue. She didn't like that answer very much. She told me that she has a power of attorney for her grandmother and asked if that would help. Unfortunately, in this situation, the power of attorney ends upon death. They ended up having to go to probate court for the property. This could have easily been avoided with proper estate planning. Estate planning is used for protecting your children. The main reason people contact me is to name guardians of their children should they pass away. This is usually the first step in feeling at ease about taking care of your children. If you do not name a guardian, a judge who may not know you, your child, or your relatives will decide who will raise your child without knowing your preference. You cannot assume the judge will automatically appoint your parent or sibling to raise your child. Anyone can ask to be considered, and the judge will select the person that they deem most appropriate. The person you name as guardian for your children when they are young may not be the best choice as your children get older. Also, this person could change his or her mind, move away, or even become ill or die. Revisit your choice from time to time, and name more than one guardian in case your first choice cannot serve. Remember, if you have not named a guardian who is able and willing to serve and something happens to you, the court will decide who will raise your kids. A court guardianship for a minor child is very similar to one of an incompetent adult. A guardianship proceeding may take months or even years and can become very expensive. Every expense must be documented, audited, and approved by the court, and an attorney will need to represent the child. All of these expenses are paid from the inheritance and can be the court, and because the court must do its best to treat everyone equally under the law, it's difficult to make exceptions for each child's unique needs. Some of the benefits of estate planning that often get missed are self-protection, creditor protection, and predator protection. Self-protection. Imagine giving an 18-year-old $1 million. Statistics have shown that within 9 months, all of that money will be spent regardless of age. What would an 18-year-old spend $1 million on? Probably not the right things. With estate planning, you can prevent your children from wasting money by putting age restrictions on access to the money. Through estate planning, a trustee or a manager of your trust could pay for necessities until the child turns a specific age. Then release a lump sum to the child. For example, you could say, I want my children to receive 10% at 21, 20% at 25, 30% at 30, and the rest at 35. This way, you know that your children are taken care of and that they will not waste the money you worked so hard to obtain. Creditor protection. If your child is irresponsible with money or if they owe creditors, the money is protected through estate planning. Because you or the trustee hold the money for the child, it technically isn't the child's money until they meet the requirements and actually obtain the money from the trustee. For example, if your child owes $20,000 to a lender, that lender is trying to collect their debt from the child. They cannot reach over into your trust because it isn't the child's money yet. In this way, the child is protected from creditors. Predator protection. This works similarly to creditor protection in that the child does not have access to the funds. The trustee handles disbursement of your assets to your child when the requirements are met and the child requests the money. This prevents a family member or close friend from taking advantage of your child. Once someone finds out that your child has money, they show up out of the woodwork and may ask for money for whatever reason. Your assets could be depleted quite quickly by others taking advantage of the situation. With estate planning, this problem can be prevented and your assets used as you intended. In situations where you cannot take care of yourself, estate planning becomes crucial. If you develop Alzheimer's, become disabled, or are in a coma, someone will need to make decisions for you. In these situations, if you do not have any documents prepared, there are multiple concerns. Because of the situation, you aren't competent to make your own decisions. Therefore, your family will have to go to probate court to have the judge appoint a guardian to take care of you and or a conservator to take care of your assets. The problem is that the judge doesn't know who should be appointed in these cases and has to look at the case objectively. This leaves room for predators to take advantage of your situation by saying, I am his brother, sister, aunt, uncle, whoever that looks good on paper, and then taking advantage of the situation. Also, because the judge doesn't know if you want that person in that role, the judge protects you by giving that person limited powers. This is good for protecting you, but there is one issue that I have, and that is Medicaid spend down. What is Medicaid spend down? In Michigan, in order to qualify for Medicaid, you can only have $2,000 as a single individual or $3,000 as a married couple. That means if you have $1 million in your accounts, you have to spend all of it down until you only have $2,000 or $3,000, and then you will become eligible for Medicaid. You might think to yourself, I have more than $2,000 or $3,000 in my account, so I won't qualify anyway. While this may be true on its face, with proper planning, there are ways to save about 72% of your assets or more for you and your family and still qualify for Medicaid. You have to have the right documents written up the right way to allow for this to take place, but it is possible. Think about how much 72% of $1 million is. That is a lot of money to save for you and your family. I'll go over a couple of examples for you. The first example is for a 72-year-old person who is single and needs 24-hour skilled nursing care. He owns a home that is $200,000. He has $25,000 in the bank, $250,000 in investments, and $100,000 in retirement accounts, which equals to be $575,000 total. His income per month is $1,250 from Social Security and $850 from pension, which is $2,100 per month. With proper planning, he can receive 24-hour care at $8,469 per month. He pays only $2,040 per month, and Medicaid will pay the rest. His home is protected, and 57% of his assets are protected as well. Without proper planning, he will have to pay the full $8,469 per month with no help from Medicaid for 44 months. He can keep his home and only $2,000. In this example, the difference between the total saved with proper planning versus without proper planning is $212,000. That is an amazing benefit of creating a complete and proper estate plan. So here's a second example. This is for a married couple where spouse 1 is 74 years old and needs 24-hour skilled nursing care. Spouse 2 is 72 years old and in good health. In this situation, their home is $250,000. They have $25,000 in the bank, $185,000 in investments, and $175,000 in retirement accounts for a total of $635,000. Their income per month, spouse 1 gets $1,250 in Social Security, and spouse 2 gets $1,300 in Social Security and $850 in pension for a total of $3,400 $2,400 per month. With proper estate planning, spouse 1 receives 24-hour care at $8,469 per month. Spouse 1 only pays $1,090 per month and Medicaid pays the rest. Spouse 2 keeps the home and 100% of the assets. In this situation, they could save 100% of their assets and still receive the care they need. Without proper planning, the couple will pay $8,469 per month for about 31 months, depleting all of their money or most of their money. Spouse 2 will keep the home and about $126,420. You work hard for your money. Please do not let this happen to you and your family. Before, you did not know about this. Now you know. You can prevent this tragic situation from happening. All you have to do is create a complete and proper estate plan. After proper estate planning to save your assets for you and your family, the state of Michigan tries to recover money spent on Medicaid for you. They try to recover the money they spent on your health care by making a claim on your assets. However, these assets are typically only the ones that go to probate court. Therefore, you can use estate planning documents such as trusts and ladybird deeds to avoid probate. The main goals in estate planning are to carry out your wishes and take care of you and your family. Avoiding probate, saving your assets, and making sure your family is taken care of when you pass away or cannot take care of them are huge benefits of estate planning. Probate court can be expensive and time-consuming, especially at a time when people should be grieving. Probate court can be completely avoided by having proper planning by a qualified professional. Also, if you do not have any documents at all, then the state will make decisions for you. Do you really want that? Trying to do it yourself can cause many problems. Some of these include the following. You do not know which documents you need and what wording to use in those documents to prevent other problems from happening in the future. This may cause you and your family headaches that could have been avoided. I know someone who created a trust, a will, and 2 other documents. The trust was not implemented properly, which means it isn't being used. That's a waste of money. Think of your trust as a pot. You have to put your assets into the pot or they aren't covered by the trust. He didn't put his assets in the pot that he created. The will said that different people are supposed to inherit the assets than what he put in the trust, and that conflicted, so that may cause problems for the beneficiaries should something happen to him. Also, he didn't have the correct information for the Medicaid planning that we discussed in the previous slides. His family is not protected as he intended. He just wasted his money. I know people who put their child or children on the deed of their house. This is wrong for at least 2 reasons. What happens if the child owes money to people? The creditor can put a lien on your home. So now you're risking your home for someone else's failures. For tax purposes, a problem is that your children may have to pay unnecessary taxes on real estate or estate taxes in general. There is a difference between putting someone's name on your property now versus when you die. For example, if you put your child's name on your house now when it's worth $100,000, for example, and you pass away when it's worth $1 million, for example, then your child will have to pay taxes on the gains of $900,000. However, if you use estate planning properly, then your child will not have to pay taxes on those gains. In Michigan, we can keep the house for you while you're alive and automatically transfer it upon your death to your beneficiaries. Just that alone will more than pay for the minimal estate planning fees that you will encounter. Remember the example with the grandmother and the granddaughter? The granddaughter only owned 50% of the home because of the way the deed was written. She had to go to probate court for the other 50%. Also, she lost out on thousands of dollars in taxes because her 50% that she acquired was at a lower cost basis, which is the amount that she purchased the house for, and she has to pay taxes on the extra amount in capital gains. This could have easily been avoided completely with proper estate planning. If you have life insurance and do not have an estate plan, Minors will not receive the life insurance money directly. A guardian will be chosen by the state, and the money may be handled by the guardian or the state. If your beneficiaries are young adults, they will have access to the life insurance proceeds immediately. Imagine giving an 18-year-old $1 million. They're going to spend it on something that's not proper. With an estate plan, you can choose the guardian of your children and at what ages they receive a portion of their inheritance. For example, 10% at 18, 20% at 25, etc. If you have an estate plan and do not have life insurance, this is also an issue. Your assets will go directly to your beneficiaries without having to go to probate court, but your beneficiaries will have to pay off the creditors. If the beneficiaries do not have any money, then the assets may be taken away by the creditors to pay off your debts to them. This is not what you're intending. Here are some issues that can easily be avoided using the systems that we have in place for you. People always misplace their documents. I have clients telling me that their parent has life insurance but doesn't know where the policy is located or even which company the life insurance is with. This can be avoided by using LawSafe. I have partnered with a company so that after you have finished implementing your plan, you can store all of your documents in an online account that's secure. You can give restricted access to other people to be able to access the accounts and find all of your important documents. I'll explain more on another slide. People forget to update their beneficiaries. You know what a big problem is? That an ex-spouse is still listed as a beneficiary on your life insurance and all of your other accounts. And the ex-spouse still has authority to make medical decisions for you. Guess who is the first person to show up at the hospital to visit you if something happens and a medical decision needs to be made? That's right, your ex-spouse. By having periodic reviews and updating your beneficiaries, you can make sure that this isn't a problem. People wait too long to create the documents. I had a client tell me that her dad has a lot of assets and she wanted to avoid probate court. Her dad was on his deathbed and had less than 48 hours to live. There is no way that this is going to happen. It usually takes about 2 weeks or so to get everything situated, and that's after you get all of your information to me. I had another client who wanted to keep her mom in a specific nursing home. She called me on a Friday and wanted the documents done over the weekend. I asked her if her mother could sign the paperwork, and she said yes. I then clarified and said that she has to be of sound mind. The client then said that her mom had dementia. She could not legally sign the documents. That's too late. I had one other client who passed away unexpectedly the week she was supposed to sign her documents. I had everything done and ready for her, but she passed away. No warning signs or anything. Do not wait until it's too late. Prioritize estate planning. I always recommend to create your documents when you get married, have a baby, or buy a house. Get them done early and you do not have to worry. I would rather have you forget that you have an estate plan in place than have you forget to create a plan in the first place. LawSafe is a secure online storage where you can upload all of your important documents such as wills, trusts, deeds, life insurance, and investment information. Think about how crazy it is that people call me and ask me about how they can find their parents' life insurance policy. They don't know which company it's with, how much the value is, who the beneficiaries are, nothing. Imagine how disgusted the person feels when I tell them they have to call all of the life insurance companies to find out if their recently deceased loved one has a life insurance policy with that company. You do not want to go through this when someone passes away. With LawSafe, you can give access to other people and even restrict their access so they can only see certain documents if needed. In case of an emergency or if you pass away, your loved ones have all of the necessary documents in one spot. LawSafe usually charges $69 per year, but I have a special offer to give my clients, which is $49.99 per year. To learn more about LawSafe, please visit my website, dallowestatePlanning.com/LawSafe. So now, we will recap what we have learned in this webinar today. Estate planning is for everyone: the wealthy, people with children, people who own a home, and people who want to protect themselves generally in case an unforeseen problem occurs. Protecting your children goes further than just choosing guardians. You can protect them from themselves, their creditors, and predators. Probate court can be avoided, which will save you money and lots of time and headaches at a time that is meant for grieving. Passing your assets to your loved ones can be enhanced by using a basic tax strategy for real estate and having at least enough life insurance to cover your debts so your family can maximize the transfer of your assets and pay for them. At Dallow Estate Planning, we want the best for you. A big problem with estate planning is that many people who create plans fail to implement them. We help you beyond just creating the plan. Once your plan is finalized and executed, I will implement the plan for your properties and your businesses. In this way, you can rest assured knowing that you, your family, and your life savings are protected. I take pride in helping my clients out when they need me. I am responsive to you and your needs. I also try to put you and your family in the best position to succeed. As a fiduciary, I am looking out for your best interest. I am not selling you a product or services. I am making a commitment to do what is in your best interest. We are committed to filling the gaps when we see them to take care of you. We have professionals in different fields that we have vetted for you to add more seats to your board of directors table. I always tell my clients two things. The first thing is, you take care of your family and your business. Let me do the rest. The second thing is that I ask them to please contact me first if they need anything. Even if you think it's something that I don't do, I will try to connect you with the right person. As you will see on a later slide, I have many credentials. I can help you in many different ways. And all it takes is for you to schedule an initial meeting with me to find out how I can help you. Now, where do you start? There is a grab your spot button on your screen. If you click on that, you can schedule a strategy meeting with me. You will get a 1-hour complimentary strategy meeting. We can meet remotely via Zoom or have a phone call. I have offices in Troy and Farmington Hills for signing documents after they have been created. In this strategy meeting, you will customize a plan specific to your goals and needs. I will help you understand what we are doing so that you feel comfortable and knowledgeable about the process and the plan we will be executing. That way you can make an educated, informed decision on how you would like to proceed. All you have to do is click on the Grab Your Spot button on your screen and schedule a meeting. At the strategy meeting, we will focus on your specific circumstances, your concerns, and your goals. Whether you are interested in guardianship of minor children, avoiding probate, protecting your hard-earned life savings, and or protecting yourself in the event of an emergency or disability or incapacity, I can help you out. Or maybe you already have an estate plan and you just need to review it to make sure everything is all set up and up to date. During this meeting, you will have the opportunity to ask me any questions regarding your situation to help tailor a specific action plan for you and your family. After the strategy meeting, we will have designed an estate plan to make things easier for you and your family, protect what you've worked hard for, protect yourself in the event of disability or capacity, and achieve peace of mind so you can sleep well at night. Then we will schedule a time to sign the documents to make them legal, valid, enforceable, and effective. I provide ongoing support and guidance such as phone calls and emails at no cost to you. This allows you to feel comfortable knowing that you aren't just left out by yourself once your estate plan is created. The strategy meeting easily has a value of $350. But for webinar attendees, I am making the strategy meeting complimentary. We intentionally limit our availability to 8 people per month so we can provide outstanding service that our clients deserve. Once slots have been filled, you will have to wait until next month to schedule a strategy meeting. You do not want to wait to schedule. My slots fill up very quickly, and you should at least find out what you need for you and your family to do based on your goals. As I stated earlier, I have many credentials and licenses. I am a licensed attorney in the state of Michigan, and I focus on estate planning. I am also an accredited investment fiduciary, life insurance agent, and health insurance agent, although I do not sell health insurance. My broad knowledge across various areas of a person's life could help issue spot and prevent problems from happening at various stages in your life. I can lay out the pros and cons of each option you have, and you can make an educated, informed decision. So, this concludes the webinar. I hope you have learned something today. Most importantly, you should not wait to create an estate plan tailored to you and your family. If you have any questions, I will be more than happy to answer them during our complimentary consultation. All you have to do is click on the Grab Your Spot button to schedule a phone call or Zoom meeting with me. Thank you again for your time and joining me during this informational webinar. You will receive a recording of this webinar so that you can view it again on your own time. Thank you.